Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. Yesterday, the 50th Chief Justice of India, D.Y. Chandrachud, retired from his post. Chandrachud, who began his judicial career as a judge of the Bombay High Court in March 2000, had been the longest-serving Chief Justice of India in over a decade. During his tenure, he played a key role in some of the most consequential decisions and developments from the Supreme Court since his elevation in May 2016. From recognizing the fundamental right to privacy and decriminalizing homosexuality to striking down the electoral bond scheme, his verdicts are likely to shape both future decisions and how the law is studied in the years to come. Last week, he sat down with the Indian Express's national opinion editor Vandita Mishra and national legal editor Apurva Vishwanath to reflect on his career. Today on the show, we bring you an excerpt from that discussion, which was part of Express Adda, a series of interactions organized by the Indian Express Group featuring individuals at the center of change. Now, here's Vandita Mishra.
First of all, thank you so much for giving us this time. It's a mark of the openness that you have tried to bring to the court, that you have come here and agreed to be with us for this session. Yours has been the longest tenure in about a decade. You've been...
Before you ask a question, can I seek a very humble clarification?
Yes, please.
Because after this, I'm going to be answering questions. In case I'm in doubt when you ask me a question, do I have the facility of a phone a friend facility as in KBC? Or maybe if you give me a breakout chat, I'll go into a breakout chat and then and discuss it with someone and then come back and answer your question.
Whatever you want. So, yours has been the longest tenure in about a decade. This is your last week. In many talks and interviews that you have given, you have spoken about your legacy. You have said that there can be two kinds of legacies. One that is measured in terms of the numbers of cases that a judge dispensed with. And the other is measured by how much the judge moved society towards greater evolution. Now, what exactly did you mean? What did you mean when you said the second one?
Any judge who assumes office, and particularly so for the Chief Justice of a court, because you're leading the court, the first and foremost issue that you confront is you have this large volume of cases. And there's no way you can duck that, because you want to begin with a certain number of cases and end your tenure with cases having come down. And every day, every Monday and Friday, we are disposing of 80 or 100 cases. So that's something which is present in your mind. But at the end of it all, you ask yourself this question: am I here to just statistically dispose of cases? And a large number of these cases are routine, small cases, not insignificant, because they make they make a difference to the life of every common citizen. Or do you want to be known, or do you perceive the role of the Supreme Court as a court which really deals with serious issues of the time, issues of moment? Now, the difficult part is bringing about a balance between the two. You can't focus only on disposing of the smaller cases to get your volume moving and to give good statistics at the end of the year to the country at large, because you can't just be piling up arrears and dealing with only the important cases. At the same time, the role of the Supreme Court is not just to dispose of cases, but to contribute to the transformation of society. And that transformation can be in terms of whichever issues you take up, whether it's gender, or whether it's federalism, or any sort of issue that you confront and which is of moment to that particular society at that time. So this is really the most challenging part of being a judge, but more so because you're the Chief Justice, because you're giving that lead to the court.
So which were the important directions that you felt in your tenure the court contributed towards pushing society forward?
When I assumed office, I thought that, while I'll pay importance to the efficiency part of my function, which is to ensure that cases are heard within a reasonable time and don't languish, at the same time, we have to ensure that we deal with the most critical issues of our time. There were constitution bench cases which were pending for maybe 2 decades. So I identified these constitution bench cases, and we dealt with almost 33 constitution bench references over the last 2 years, involving 9 judge bench issues, issues before 7 judges, issues before 5 judges. Now, I'm not going into what issues they dealt with. They dealt with a wide range of issues, including as to whether a legislator, for instance, who is accused of taking a bribe or giving a bribe for casting a vote in Parliament is immune from prosecution, or whether there's a right to marriage equality for queer couples, or, for instance, something on arbitration law. We've dealt with issues extensively relating to the federal structure of India. Who has the right to tax royalty? Do the states have the right to tax royalty, or is that within the domain of the union government? So these are some of the issues which we have been dealing with and exploring. Some of them make headlines and go into the news. Others are very significant for the nation in the future. But equally, I thought this was going to be a key part of my mission over the last 2 years. And we've been able to do that. In fact, we are going to declare judgment in 2 important cases tomorrow. Since this is last week now, I have to complete the backlog which I have on my file.
When we talk about moving the needle, something that we notice in several of your judgments is, you talk about these issues which might be too early for legislation, but seemingly happening in our society that are documented in, say, court proceedings or a judgment. In a service matter, you talked about atypical families and how they exist, and the law has to cater to those. You talk about, say, the right to abortion of an unmarried woman, or even the same-sex marriage case. These are conversations that are very important, that need to happen, but may not be happening in the legislative space. But where do you see the court's role in facilitating these conversations? Because they are very important, and we already know they're happening in the society. Does the court reflect from that, or is the court showing new direction to these issues?
Well, we are a constitutional court. And as a constitutional court, our function is not just to decide cases, but to promote a dialogue between different segments of society, to create a space for democratic dialogue. A democratic dialogue with a rational framework, not having people just scream at each other from different ends of the spectrum, but an ordered, rational discourse in court. And I think that is a very critical part of the work which courts do, to create that space where people can come to court. Whether they succeed or not is not besides the point, but not as important as the nature of the process which goes on. And from that perspective, for instance, say in the case of the same-sex marriage equality case, we didn't give queer couples the right to marry, or on the question as to whether they are entitled to a civil union. I was in a minority where I said that same-sex couples should have the right to form a civil union. The rest of my colleagues, Justice Kaul and I were in the minority. 3 of our colleagues took the other view. But nonetheless, opening up these issues for public debate, for critique and criticism as well, is very important, because that's when we ensure that society starts thinking about these issues, reflecting on these issues, and responding to what the court is saying. So it's not just in terms of the outcome in the court which is important to my mind, but also in terms of the process. Very often colleagues ask me as to why I give so much of time in my court. And the reason why I give time to the expounding of arguments, of course, it's the last court. There's nothing above this, not even the International Court of Justice. But the reason why I give a lot of time to cases is because I do believe that the process itself has a great degree of healing power, the catharsis of an Indian citizen coming to court and realizing that they had their day in court, their voice was heard, irrespective of whether they have a voice in the political system or not. And that ability of the court to give a voice to people in distress I think is a defining feature of our system.
So this role that you see of the court as a forum of a larger conversation, a larger debate, a participatory debate. You've also spoken about how judges need to be to judge without being judgmental. So in today's environment where polarization is growing, these spaces are besieged, whether it is in parliament or it is in the university campus. There is that space for that kind of a broader, inclusive dialogue where people can hear each other with respect, even when they disagree with each other. That space is shrinking everywhere in all institutions. How does the court protect that space?
In a sense, the court protects that space by the discipline of the law itself. Because what goes on in a court is not just a street-level conversation of people who have two opposing viewpoints, but a conversation which takes place within the framework of the law. So long as we structure the conversation within the four corners of the Constitution or the four corners of the law, and the judge has a very vital role to play in that, in the sense that there are times in courts where the conversation tends to get out of hand. You see that on the live streaming in our courts every day. But when you feel that the conversation is tending to get out of hand, it's, I think, the duty of the judge, and perhaps also part of the craft of the judge, to move the conversation back to the center by asking parties that, hey, we are here not to discuss politics. We are here to find solutions within the framework of the rule of law. And I do believe that parties do respond. They realize the limitations of the court, but they also realize the potential of what can be achieved through the court. So both understanding the limitations of the dialogue in the court and understanding the potential of that dialogue, both are equally important. But at the end of it all, you have to constantly tell yourself and tell people who are appearing before you that what we are discussing is to find solutions to injustice within the framework of law.
One of the defining things about your tenure is how the courts have been opened up to a larger audience. It's not just a bunch of court reporters in the court or the lawyers who are privy to what happens, but everybody who has a stake now watches what happens in the Supreme Court. It's a wonderful thing. It brings in a sense of openness that was never before, but it's also something that, like you talked about, criticism that, it brings in with it, which I think the court was not, in a sense, used to even say a decade ago or even before the pandemic. So how do you see this 24/7 scrutiny that judges face now, including you yourself? So are we prepared for this sort of discussion and debate on what the Supreme Court does?
Well, I think we are. But I'm not looking at it as Chief Justice only from the perspective of the Supreme Court. I'm also looking at it from the perspective of the High Courts and the District Courts, which the District Courts really are at the base of the pyramid. But that's the place where our citizens first come into contact with the law when they move a court. Speaking about the Supreme Court, I think COVID itself was a game changer, because if we had not, progressed to hybrid hearings, video conferencing solutions, I don't think we would have been able to function. And there's no way a court could have just pulled down the shutters in COVID and said, well, we're not available for work. What COVID did was we had robust technological infrastructure in our courts, and we began at a very rudimentary level. And then we, of course, took it to a different level over a period of a year or 2 years thereafter. But what opening up the courts has done is that the dialogue in the court is not just confined now to, say, the 50 or 100 or 200 people who are present in the court, but the dialogue reaches out across the nation and even globally. So I know that many cases that we have dealt with have a global reach now, because people want to know what the Indian Supreme Court is doing. And in that sense, I think it's reflective of the soft power of our nation that we engage in these serious dialogues, because not too many countries in the world can say that, well, we have the kind of open critique, dialogue and discussion that goes on in our courts. Are we ready for this? To be very honest, I think that a lot more needs to be done. For one, I find very often that judges are not conscious of the fact that you're now reaching out to a much larger audience. Every word that you say in court tends to get evaluated, it tends to get discussed, sometimes fairly, sometimes unfairly. What happens is in a court, you find there are two kinds of judges. The first sort of judges are judges who agree with the lawyer who is arguing. And the idea then, when you're agreeing with the lawyer who is arguing, is to stretch the limits of the argument. So how far can we take your argument? So you're not actually going to agree necessarily in your final judgment. The other sort of judges are those who play the devil's advocate, who are constantly telling the lawyer, but you're wrong for this reason. Well, you haven't seen this. Now, the purpose is not to tell the lawyer that I'm going to decide against you, but to get the lawyer to really, to bring out the best in the case. So you have two kinds of judges. Now, what social media and the live streaming has done, in the sense, not so much the live streaming, but the social media, is that there's a perception that all that is said by a judge is going to be the final verdict, which is not so. It's an open dialogue, and the judge is open until the last minute. And I can't tell you how many cases you change your mind in a rejoinder. You hear a young junior lawyer who is arguing in a rejoinder, and you say, well, there's some substance in what is being argued. And that's what we are trained to do, to keep our minds open until the end. So this is the flip side, of course, of people also not realizing that everything which is said in the court will not necessarily be indicative of the line which the court will ultimately take in deciding the case. What's going on is a dialogue to find where the truth lies, and which is a very complex issue. I think we need to train our judges as well, because judges have to be more receptive to the concept that your reach now is so huge. You find that judges make sometimes an off-the-cuff remark, and we've had to deal with that as a Supreme Court in the recent past of
like the cycles. Karnataka judge who
right. So I think it's important that our training institutions, we have judicial academies all over the country, that some element of effort has to be now devoted to make judges be in tune with the new normal, which is not to say that they shouldn't be their normal self in the court and hide what they have to think about a case, but to also use language which is appropriate. We have brought out a gender handbook recently in the Supreme Court to make judges and lawyers aware of gendered language in court, and why we shouldn't be using gender pejorative terms or terms which are pejorative to people with disabilities. So there's a lot more. It's all work in progress. But overall, I think that it's been a huge game changer, because we've been able to reach out to people and strengthen our role as the people's court, that we exist for people. And though we deal with very small cases, somebody's pension, somebody's service benefits, a motor accident where somebody has lost their life and somebody is making a claim for 5 lakhs of rupees, a small farming family, an agricultural family making a claim for 5 lakhs of rupees. So this is the kind of work which the Supreme Court does every single day. And that sort of promotes the sense of confidence in the work of the court, which doesn't get the headlines, because these are not cases which are, in that sense, groundbreaking cases for the nation. But to my mind, they're extraordinarily important. And this work of live streaming and, the hybrid hearings has enabled us to truly reach out to people.
So in the same spirit of openness and dialogue, if I may ask you about 2 controversies that have been sparked off in your last few days in your tenure. So the first was about you praying with the Prime Minister, the photographs and the videos that came out and raised questions. And the second was when you said that ahead of writing the Ayodhya title suit judgment, you sat in front of the deity and asked what the solution should be. So you have answered on the first one, and you have said that there is a maturity in the system, that the executive and judiciary can interact, and there should not be and there need not be questions about any deals being struck or judicial verdicts being influenced. But Justice Chandrachud, the problem, the objections that have been raised have to do with the fact that there is a political context in which these photographs appeared. The same Prime Minister was almost functioning like the head priest at the consecration of the Ayodhya temple in January. There is a message that could go down the line to the district judiciary, because these are times also where a very strong executive has led to the blurring of lines, that the separation of powers as well. There is an executive that weaponizes its mandate or has a winner-takes-all attitude. So in that context, those photographs raised concerns. And the second, when you say that you ask the deity for a way forward, it is in a case where the two sides are actually, they belong to two religions. So how would you please elaborate on both?
Certainly. Thank you for asking me this question, actually, because I sometimes feel I don't have a platform to speak, because judges predominantly speak through their judgments. First and foremost, at a doctrinal level, the separation of powers concept does not postulate that the judiciary and the executive are antagonistic in the sense that they will not meet or that they will not engage in a reasoned dialogue. In the states, there is a very well-established protocol in several states, including states where I have served as a judge and then as a Chief Justice, of the Chief Justice and the Administrative Committee of the High Court meeting the Chief Minister, and on the next occasion, the Chief Minister meeting the Chief Justice in their residence. And in most of these meetings, for instance, when I took over as Chief Justice of the Allahabad High Court, you're discussing basic issues which concern the judiciary: budgeting, infrastructure, homes for the district judges, new courtrooms, technology. And because the budget, we have to realize, comes from the executive. And unless you talk to, well, you could do that on paper and then wait for the next 5 years to get your issues resolved. There's a question of prioritizing your projects. So, there is this very robust dialogue which takes place between the executive and the judiciary on the administrative side, which has nothing to do with the judicial work which you do as judges. That's one thing which I must clarify. What the separation of powers postulates is that the judiciary should not be performing the role of the executive, which is defining policies, because the power to frame policies belongs to the government. The court can decide on the legitimacy, the constitutional validity of a policy or a legislation. Likewise, the executive doesn't decide cases. The legislature doesn't decide cases. The court doesn't frame laws. That's the essence of the separation of powers doctrine. And I think so long as we have this in mind, and there is a realization that, in fact, there are areas, the doyen of the bar, when we had a little bit of an impasse at the beginning of my tenure as Chief Justice of India on certain issues, particularly appointments, Mr. Fali Nariman said, why doesn't the Chief Justice have a dialogue with the law minister? And, the doyen of the bar saying that carried a lot of weight. The point of the matter is that dialogue does take place, and it has to take place. And why is that dialogue necessary? You're dealing with the careers of people, you're dealing with the lives of people who are going to enter the judiciary, or those who are already in the judiciary who are going to go higher. There are things which you have to discuss in person. Now, we have to accept, therefore, the fact that there is a great amount of dialogue which must take place as a part of a robust interinstitutional mechanism for the exchange of views. And this has nothing to do with the way we decide cases. Over the last 75 years, that's a tradition which has evolved, which is that you don't discuss about pending cases. That's been my experience in the high courts. That's been my experience in the Supreme Court as well. That is the first aspect which you asked me. On the fact that, the Prime Minister visited my home for a purely private event, it was not a public event. Well, I do feel that, there is absolutely nothing wrong, for the simple reason that these are continuing meetings between the judiciary and the executive, even at a social level. We meet in Rashtrapati Bhavan. We meet on the occasion of the 26th of January, on the 15th of August. when an incoming Chief Justice is coming, when an outgoing Chief Justice is going, when, a foreign head of state is visiting, and you are in conversation with ministers, you are in conversation with the Prime Minister, you are in conversation with the President, with the Vice President. Now, these conversations do not involve conversations about the cases which we decide, but conversations about life and society in general. For instance, when I'm sitting next to a foreign head of state, or I'm engaging in a conversation with maybe a senior minister, I would probably ask them something very interesting about world affairs. So there has to be this sense of maturity in the political system to understand this and to trust our judges. Because ultimately the work which we do is evaluated by our written word. Everything that we decide is, unlike, say, many other systems, not kept in the wraps. Our reasons are open to scrutiny. Why we have decided a case is open to scrutiny. Your second question, which was in relation to what I said, I think that's again a problem of the social media, which Apurva just mentioned a short while ago. You must have the backdrop of where I was speaking. I visited my village, which is about 1.5 hours away from Pune. It's a village called Kanersa, predominantly agricultural community. And one of the questions which I was asked was that in the arena of conflict which you find in your courts, how do you stay still or how do you stay calm? That was a question which I was asked to specifically made to answer. I said everyone has his own mantra. And by mantra, again, I don't mean the religious mantra, but the mantra of life. Somebody may want to exercise, somebody wants to trek. I said, so far as I'm concerned, I spend an hour every morning in reflection about what I'm going to do, how I'm going to handle my caseload for the day, how I'm going to handle this arena of conflict in which I perform my public duties every day. And I said that, and when I said that I sit before a deity, I make no bones about the fact, and I'm not defensive about the fact that I'm a person of faith. I have my own faith. Equally, I respect every other faith. And that's the kind of work which we do. My being a person who professes a particular faith has nothing to do about how I will treat people of different faiths who come in conflict and come in court seeking justice before us. So what I answered was that, of course, we answer, and this in response to your question, how do we decide cases? And I must put that point against me as well. Because, people said, now the judges of the Supreme Court are appealing to a divine power to tell them the answer to a case. That's really now putting what I said on the head. What I said was this, and what I mean was this. Of course, every case that we decide is decided in accordance with the principles of law and the Constitution. And whether we do that or not is again subject to scrutiny. We are going to deliver 2 judgments tomorrow, and you'll see whether they are decided in accordance with the Constitution and the laws. But having said that, the same judge who applies the law can do justice, but as a human being, there's always a prospect that the same human can commit an act of injustice. You see, in colonial times, the same law was used as a means of oppression. The same law can be used as a means of providing justice. So what is the distinction? How do you ensure that as a human being, you use the authority which is given to you under the law to do justice as opposed to doing injustice? And that's where your own sense of equanimity comes to the fore. How do I maintain my own sense of equanimity in an arena of conflict, intense conflict, and not just conflict between, say, states in the union or between 2 political parties, conflict between husband and wife, conflict between 2 warring corporate houses. And that's where I feel that whatever way you adopt to maintain your sense of calm is very crucial to having an ordered discourse and ordered outcomes in the work which you do. And I believe that if someone feels that, it's their faith which gives them that sort of calm, because it's that sense of calm which gives you the degree of objectivity to look beyond the conflict, so be it. And I think that people must accept. And the fact that you belong to a particular faith has nothing to do about your ability to do justice to people of different faiths as well. So long as we accept that, I think, one look at our cause list, one look at our daily cause list, which incidentally I don't look at because, they're names, but one look at the daily cause list would just indicate the diversity of India which comes to our court every day and to whom we try and do justice.
But if you had a chance, would you go back and tweak that frame a bit? Would you include perhaps a few brother judges in it or the leader of opposition in it? Would you redo that frame if you could?
Well, I wouldn't include the leader of the opposition because it is not a selection committee for appointing the Central Vigilance Commissioner or the director of CBI. So I wouldn't do that. The other thing, contrary to what people feel, on occasions such as marriages, occasions such as death, there are social visits. When my mother passed away, I had a visit from the political head of the executive in my state where I was Chief Justice. What do you speak on the occasion? The Chief Minister didn't know me or my mother. You just come and sit for 5 minutes, express a little bit of, a sobering thought, and leave. These are just elementary courtesies which are followed in the system. And so long as we accept that, I think we must accept that we have this. Our judiciary has a sense of maturity. We've been all around for years and years. Members of the political executive visit homes on the occasion of marriages. Likewise, we are invited when there are marriages or other events which are going on. The fact of the matter is, as I said, deals are never cut like this. So please trust us. We are not there to cut deals. And the ultimate guarantee of our good behavior lies in the written word which we produce. Does that written word make sense? Is it consistent with the Constitution? We may err. To err is human. And it's for everyone in society to judge a particular case which we have decided, whether we have decided rightly or wrongly. That's a different thing altogether. But to sort of cast, impute motives to judges is perhaps denigrating the system.
Justice Chandrachud, we talked about, conflict and the idea of justice. We are also in the midst of 2 global wars, which seem to be never ending. And like you said, the same law that was applied differently in colonial times is applied very differently now. But we are also at the 75th year of our Constitution. What is the idea of justice for you? And how does a citizen, and I mean a global citizen who's looking at what's happening in Gaza, who's looking at what's happening in Ukraine, how do we look at the idea of justice?
The idea of justice, first and foremost for somebody who spent their life in the law and as a judge now for the last 2 decades, is judging within the purview and the framework of law. In the sense that when you deliver justice or you're trying to unravel the complexities of a case, you have to apply some fundamental values in order to define the notion of justice. Now, what are those values? Those values, to my mind, are the values which are given to us by the Constitution. And those values are not abstruse. Those values are very simple. The fundamental value and the most important of them is the value of human dignity. Valuing every life as equal to another life. Fraternity. Valuing the fact that we are all a diverse melting pot of ideas, cultures, religions, social frameworks. That's fraternity and bringing us all together. The freedom of speech. Again, one of the critical values which sustain democracy. Liberty of thought expression, belief, faith, and worship. Equality. Equality between not just 2 people, but equality as between social strata. So these are fundamental values which I believe that every judge, by their very training, and why just every judge, every citizen of the nation has to bear in mind. Because these are really the cardinal values which have sustained our society and contributed to a very stable society which we have been able to survive over the last 75 years. When the Constitution was framed in, 75 years ago, there was a doubt which was expressed as to whether the nation would survive, and we have survived these last 75 years. And to my mind, the reason why we have survived as a nation has a lot to deal with these fundamental constitutional values which have been given to us. And obviously, at times they've come under strain, but we have emerged from those strains as well, historically speaking. And the idea of justice, therefore, is founded in an effort to arrive at outcomes which should be consistent with these fundamental values. Sometimes you find a sort of divergence between the law and where the law leads you and where these values should lead you. And particularly if there's no challenge to the law, then you're constantly asking yourself, well, how much can I stretch the law? And can I mold the law to arrive at a just decision? And that's the craft of a judge and the craft of a good lawyer. To assist the judge in sort of deciding as to how, without breaking the law, you can use these values to have a more just outcome to the extent that you can within the framework of law.
You have spoken of the Supreme Court as the People's Court. You have also spoken of the pressures on the People's Court. You at one point said that, I'm not a magician. You at another point said that there is a pressure on the People's Court to take on the role of the opposition. Why did you say that? And secondly, did the June 4 verdict ease that pressure on the court? Because there is a perception that after the verdict, the court has been talking back to the executive in a way that it wasn't for many, many years.
Let me answer your question to the best of what I can say. I've said that the court's work and role is not that of a political opposition, and I maintain that. The reason I say that is because traditionally, judicial independence was defined as independence from the executive, independence of the judiciary from government. Independence of the judiciary, even now, means independence from the government. But that's not the only thing in terms of judicial independence. Our society has changed since, say, the 1950s or 1970s, particularly after 1990 when the market reforms took over. And particularly with the advent of social media, you see the growth of interest groups, pressure groups, groups which are trying to use electronic media to sort of put pressure on the court to arrive at certain outcomes. What you increasingly find is that a lot of segments of these groups say that, well, if you decide in my favor, you're independent. If you don't decide in my favor, well, you're not independent. And that's what I have an objection to. To be independent, a judge must have the independence to decide what their conscience tells them. Of course, a conscience which is guided by law and the Constitution, as I said. When you decided electoral bonds, you're very independent. But if a verdict goes in favor of the government, then you're not independent. That's not my definition of independence. You must give your judges the leeway and the freedom to decide as they feel the balance of justice lies, irrespective of whom the verdict is going to go in favor of. And this is truly my concern, that today it's expected that, well, we'll treat you as an independent court, provided you constantly hold against the government. Well, in cases which have to go in against the government, we decide against the government. But if the law requires a case to be decided in favor of the government, and I'm not just talking about, the big ticket cases, but a taxation case, a service case, you have to decide in accordance with the law. That perhaps that message has to go across, which I think is crucial to the existence of a stable and vibrant judiciary. On the latter part of your question as to whether the verdict of 4th of June has made a difference, the atmospherics may suggest that, these things make a difference. I don't believe so. We decided the electoral bonds case even before the 4th of June verdict, right? We, in fact, decided the verdict much before we even went into the electioneering mode. So these are not issues which really affect judges, but building a consensus within the court, building a direction in which you should be going, requires a certain degree of deliberation. You don't suddenly change tack overnight in court cases. Judges take time they decide cases, in incremental changes. And that incremental change coming in from the court is very crucial, also to maintain the stability of our jurisprudence, to ensure that there are no radical shifts from the left to the right or from up to the down, and that you're steering a clear course, making incremental adjustments to justicing outcomes, so that overall the court is a force of stability in society.
In your speech at the Cambridge University, you spoke about the silences of the Constitution. One of the things you said was fascinating. You said, in the manor farm, although the animals declared that all animals are equal, it didn't end up so. And that you use that example to say that you need processes and institutions to ensure all animals are equal. So what are the institutional processes or mechanisms can we have to prevent, say, G.N. Sai Baba or Stan Swami not ending their lives like the way they did? And this is the larger question about delays, and how do we address these?
Well, let me address the question of bail first. Very often, what happens is that in the media, particularly the journalistic media, a particular case assumes prominence, and then the court is either criticized or critiqued on the basis of one particular case. I'll give you concrete statistics. After I took over as Chief Justice on 9th of November 2022, I thought that we must prioritize bail, because bail fundamentally impacts upon personal liberty. So every Tuesday, Wednesday, and Thursday, and of course Mondays and Fridays, I ensured that at least 10 cases would be given to every bench involving bail. Between 9th of November 2022 and 1st of November 2024, 21,000 bail cases were filed in the Supreme Court. During that period, 21,358 bail cases have been disposed of. So these are just hard statistics. Going to say the PMLA Act, which has been a matter of great public debate, particularly in the media, about 967 odd cases have been filed in that period. 901 cases have been disposed of. So that just gives you, statistically speaking, the kind of disposal and the kind of work which is being done by the court in areas of personal liberty, and the importance which is given to personal liberty. Now, for the one or two cases which you did mention, I can tell you at least a dozen cases, sensitive cases, somebody will call them politically sensitive cases, or politically important personalities, whose names I don't think I should be mentioning as the Chief Justice of India, where we've dealt with those cases and bail has been granted. That's happened over the last several months and even before that. Now, what happens is that, very often in the media, a certain facet or a certain atmospherics of a case are sort of made out. When a judge applies their mind to the record, what emerges from the record may be very different from what is portrayed in the media on the merits of that particular case. And the bench of the court which deals with that case and decides, in your example, as to whether to grant bail or not, and I'm not commenting on any particular case because none of these cases have been dealt with by me, and I'd like to respect the fact that my colleagues have dealt with it, and I respect those colleagues for the work which they do. So ultimately, the judge has to apply their mind to the record of that particular case. Whether they are right, whether they are wrong, is something for everybody else to critique. But the judge looks at the record and then decides what to do.
But Justice Chandrachud, if I may also jump in on the bail issue and add another name to the ones that Apurva mentioned, Umar Khalid. So, there have been cases of the Delhi riots cases. There's also the Bhima Koregaon cases, where for years and years, bail has been denied, or the court has simply kicked the can down the road. Where do you think, I'm asking you as the CJI, as a distinguished jurist, where do you think the problem lies? When the Supreme Court says that bail is the rule and jail is exception, why does this not translate to, let's say, the lower courts? Also, when the Supreme Court intervenes in one bail case and grants bail, and in another it lobs the ball to the lower court, why does it look arbitrary in doing so? Why is habeas corpus not the cornerstone that it should be?
Speaking for myself, I've always said that I've granted bail from A to Z, from Arnab to Zubair. So, and that's my philosophy, because you have to look at the nature of the offense. You have to look at a variety of circumstances when you decide a bail case. Prima facie is a case made out. Is there a likelihood of the trial being prolonged indefinitely? Is there a likelihood of the accused tampering with witnesses? Is there a likelihood of the accused not being available to face trial? These are some of the parameters which we apply for the disposal of cases. Now, very often it is believed that, the Supreme Court has lobbed the case back into the lap of the trial court. When the Supreme Court does that, it does that for the simple reason that there has to be an ordered procedure for accessing bail. Somebody comes to the Supreme Court first only because they are resourced or because they have lawyers who sort of take up that case. The court is justified in saying that, we are not going to make exceptions for you. You must first approach the trial court. I do have concerns for the reason that we increasingly find in the Supreme Court that the trial courts are reluctant to grant bail. And this is something which I've spoken about. And that's a matter of concern for me as the Chief Justice of India. Because the principle that bail must predominantly govern and not jail, this message has to permeate down to the trial courts. Unfortunately, it has not permeated. And I've said that on more than one occasion, that that's a matter of grave concern for me. Why is that so? I think we have to understand that perhaps there is this culture of distrust about the system. There's a culture of distrust about public officials. There's a culture of distrust. So if a trial judge grants bail, there's a perception in the mind of the trial judge that perhaps people will believe that I granted bail for extraneous reasons. That sense of distrust, how do we get over? We have to get over by that sense of distrust by creating greater confidence in society on the part of those who have to decide cases. Now, I think the media also has to do some soul searching. That in our effort to, reach out to every case, 24/7 and report every little detail of the case, are we then perhaps doing exactly what we shouldn't be doing, which is to affect public confidence in the judicial process and affecting the sense of confidence of our trial judges themselves? And that distrust you find in government as well. You find, for instance, that every case which is litigated at the lowest level comes to the Supreme Court. Now I ask myself, why have they come to the Supreme Court in this case? And the reason is very simple. Government officers don't want to take that ultimate call that, this case involved 5,000 crores. And I said, there's no merit in the case. The government officer said that there's no merit in the case, and let's not go to the Supreme Court. People are worried. Will there be an inquiry? Will there be an FIR against them? When their promotions come up, will they be subject to targeting on the ground that, you unfairly compromised a case? This is the prevailing culture in society, as a result of which, across the spectrum, you find public officials, including judges at the lowest level, worried about the fact that there would be this assault on them if they were to decide in a particular case. And that is, Vandita, that is a matter of concern for me. And I think, therefore, we need to strengthen the district judiciary, first and foremost. The Supreme Court granting bail, which we do, but we do that after the entire procedures have been gone through, and sometimes the procedure itself is the punishment, is good, but it's not good enough. That message has to permeate down to the system. How we create that sense of confidence, that how we ensure that there is no lack of distrust in our district judiciary is a complex issue. I don't think I have an answer which can, overnight change things. But this is the reality of our system.
I want to ask you about another important issue of judicial appointments. And there are two aspects to this. One in how you choose, and second in how those names eventually see the day of light. In your tenure,
what is the second thing?
How these names eventually see the day of light, how they're appointed eventually. There is this sense of disquiet in the bar that there is a long waiting period, or that even if my name is recommended by the collegium, that my turn may never come. In the beginning of your tenure, you reiterated about 3 names, out of which only one has been appointed and is a sitting judge of the Bombay High Court. But 2 other names in that same list, which were reiterated for the 3rd time, never got appointed. Does it worry you that there are young members in the fraternity who may not want to be a judge? Because maybe not now, but 10 years, 15 years down the line, that could be a problem.
Now, first, let me give you the overall perspective of what's happened in the last 2 years. During the time that I took over as the Chief Justice of India, 18 judges of the Supreme Court have been appointed. 40 out of 42 Chief Justices that I have made recommendations for, together with my collegium, have been appointed. 2 are in process. 137 out of 164 appointments that we proposed for appointment as judges of the High Court have been appointed, and they are in saddle. And 65 cases were cases which we, as the collegium in the Supreme Court, we rejected or remitted. And they are now obviously pending with the government, or they've gone back to the high courts. Therefore, this is overall the broader picture, because I think it's important that we have this broader picture before us, that 137 out of 164 appointments which we recommended have been made. 27 are pending with the government. You referred to certain cases where we have reiterated names, and the government has still not cleared those names. The memorandum of procedure provides for the outcome in such a case, which is that once the Supreme Court reiterates a name, the reiteration is binding on the government, and therefore that has to be sent to the President of India. Some of those names are still pending before the government, and you mentioned some of them. Well, I hope that they are cleared by the government. We have done everything which is within our power as the Supreme Court to ensure that we do our part of the constitutional process, evaluate the names, discuss the names, and we send the names to the government. I must also share with you that in the collegium, the process which we follow has a great deal of application of mind. We consult judges from that High Court who are part of the Supreme Court. So if I'm looking at judges who are to be elevated to the Bombay High Court, I would be consulting judges of the Supreme Court who have routed through Bombay as either Chief Justices or judges, likewise for the other High Courts. That is done. We have inputs which come at a different level. We have inputs which come from the Intelligence Bureau, the inputs from the Department of Justice. We evaluate all those inputs. We send them back to the government. So we have done everything within our power as the court, as a collegium, to deal with these files, send them to the government, and some of them are pending. I've made an effort at transparency by putting out all the resolutions of the collegium on the internet. So people at large should know why we have proposed a name. Why is it that we found this particular judge worthy of appointment as a judge? In a given case, for instance, where the sexual orientation of the judge was an issue, we put that out on the internet in our resolutions. And hopefully, I think at some point of time that should be cleared.
But does this not alter the veto that the Supreme Court collegium has? If the government just indefinitely does not make an appointment, does that not alter how we essentially look at judicial appointments in this country?
This is something which has not really been told, and I don't think people have appreciated this. Yes, there are multiple stakeholders in the appointment process. You have the High Court collegiums, you have the governments in the states, namely the Chief Minister and the Governor in the states. You have the Supreme Court collegium. You have the Government of India, which is going to evaluate all the inputs which are brought on the file to them. And of course, the file then goes to the President of India for clearance. Now, the veto, I must tell you, is not a veto which is exercised only by the government. That's something which has not been appreciated. The veto is exercised by the collegium as well. No appointment can go through unless we clear the appointment. Very often when we get names from the high courts, those high courts have generated those names. There is obviously, in many of those cases, some element of the involvement of the state executive in the recommendation of their names. There is a discussion with the state executive where we find that a particular candidate is not worthy of appointment and we veto that. The Government of India can't appoint that candidate. So there is, in that sense, a veto which goes on at two ends of the spectrum. We ensure that people who we do not believe to be worthy of appointment should not be appointed as judges. Well, what is of concern to me is, of course, that even if some names have been cleared by us, and that name is still not being cleared by the government, of course it's a matter of concern to me as the Chief Justice of India. But to say that, we are subservient to the government would not be correct. Because we as the collegium have exercised our authority to deny appointments where we felt that some people don't deserve to be appointed.
So, Justice Chandrachud, there's been a lot of talk about the basic structure of the Constitution and the perceived threat to it by government with a very large mandate. In the recent Lok Sabha election, there are fears that the Constitution could be changed, that the reservation framework could be altered, also played a role or are said to have played a role in the mandate that eventually was given and the reduced mandate to the ruling coalition. As you step down as Chief Justice of India, are you confident and assured that there is no threat to the basic structure, or that the basic structure is not vulnerable to being altered by the government or the politics of the day? Or does it give you a little bit of a sleepless night?
Vandita, the more I've looked at the social fabric of the nation and you look at the diversity of the nation, the diversity of the nation is not something which is amenable to change by law or by constitution. It is a given. The diversity in terms of regions, the diversity in terms of religion, diversity in terms of language, diversity in terms of cultures, which is itself a source of the multiple identities which we have within the rubric of the overall nation. We're all citizens of the nation, but each of us carrying different identities. This diversity, to my mind, of the nation is the most stabilizing force. I mean, you would expect that diversity would be a factor which would detract from stability. But looking at the history of the nation over the last 75 years, it's actually that diversity which has propounded the stability of the nation. And when you look at this diversity, that diversity it is which protects the basic structure. Because the basic structure of the Constitution is, of course, a constitutional concept. Incidentally, it came from a German scholar, Dietrich Conrad, and then it was adopted by Mr. Palkhiwala when he argued Vishwanath Bharati. But basic structure is a constitutional concept. But let's be very clear. Basic structure is also grounded in society. It's grounded in politics. It's grounded in regions. And every time that, you look at the flux in the nation in terms of the evolution of the social fabric, you realize why the basic structure has survived. It's not survived only because of the strength of the constitutional concept. It's essentially survived because of what society is. A society which is so deeply cultural society which is so diverse, which is so inclusive. And these forces of inclusion, they are so powerful, particularly in our society, that they bring us together and ensure that fundamental democratic values, which is what the basic structure doctrine is all about, are preserved. Therefore, I have cause for optimism for the future.
You were listening to Three Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.